this morning the attorneys advised me that they have potential settlement that they're desirous to put on the record, and thereafter I will allocate the parties, and we will see how it goes. Mr. Sussman, will you be putting the stipulation on the record?
Yes, Your Honor. Thank you.
Thank you.
First of all, before I go into the terms, I do want to thank the court for assiduous efforts to assist the parties in resolving this case. It's not an easy case, as the courts recognize, and without your assistance, I don't know if we would have reached a resolution, so thank you for that. I also want to compliment the professionalness of Mr. Steinberg and Mr. Gold and the county attorney, because I think they assisted significantly in coming to where we are right now. So I want the record to reflect my appreciation for their efforts, as well as understanding the difficulty of this for all involved. And Mr. Smith, I certainly appreciate the position you're taking in helping to resolve this matter, which is of some public importance in this county. That all being said, Mr. Levy has agreed, Your Honor, to dismiss this matter with prejudice on the following terms. There will be a payment of $150,000, $125,000 of which will be coming from the county to me as attorney for Mr. Levy. $25,000 will come from Mr. Smith to Mr. Levy and to my office, but payable to Mr. Levy. There is a agreed upon attachment or exhibit A, which is a letter of retraction and apology, which is being signed by Don Smith in his capacity individually, which is the capacity in which he was sued. The sheriff will cause to be removed from the Putnam County Sheriff Office website letters which were the subject of this case, letters that the sheriff signed on the 21st and 22nd of March, and he will place prominently on that website the retraction and apology letter, which is Court Exhibit A.
Excuse me for 1 second. I believe we already had a court exhibit number 1. It was the media application, so I'm going to have it marked as court exhibit number 2.
Thank you, Jeff. You have a copy of that signed, I believe.
I do. Do we have one marked yet?
It's not marked.
I will hand it down and be marked now. Thank you. Hold on one second.
This is all I realized what I was doing.
Thank you.
Mr. Smith has also agreed, Your Honor, to a non-deprecation provision which applies to him and him alone. That provision disallows Mr. Smith from making public comments which are denigrating and deprecating Mr. Levy, disparaging Mr. Levy. Mr. Smith is permitted to fully participate, as he is a litigant in the lawsuit versus Putnam County litigation. That non-disparagement provision has nothing to do with limiting him in any way in that particular proceeding. And Mr. Smith, as the sheriff of the county, we understand may be contacted by law enforcement with regard to inquiries of anyone, including Mr. Levy or anyone else, and it's our understanding that he would truthfully and honestly respond, and be able to truthfully and honestly respond to those inquiries with no limitation. The only obvious limitation is that he be telling what he knows to be true. If Mr. Smith is found by a court of competent jurisdiction to have violated the non-disparagement and non-deprecation agreement, a liquidated damage sum of $50,000 has been agreed upon as the sanction, along with attorney fees reasonably incurred and demonstrated to the court by the standard imposed by that court and the law of that violation. I believe, Your Honor, that those are the terms that these parties have agreed to. I think Mr. Kleinberg and I have agreed that there need to be no further written settlement agreement as such. These are the terms, and there need to be no further agreement. The only other matter is that Mr. Levy and I will both provide for the settlement agreement W-9 to the county, which will allow them to make the payment. That's Mr. Smith, which will allow him to make the payment. Other than that, it's a ministerial matter. Nothing further. I just want to close by saying the following briefly. This is public law litigation. It involves matters of public importance. I think both sides now recognize that, and I think both are committed to seeing business in the county be attended to. Thank you.
Very well. Will a stipulation of discontinuance with prejudice be filed in this court?
We can file that within a 2-day period. I think if you want that in writing, we will do that after the allocation.
Very well. Counsel, is there anything you'd like to add?
No, just that the county will have to adopt a formal resolution, but this will be accepted and discussed now.
Have you had occasion to speak to people who represent the county legislative group?
You're going to have the county attorney here today to represent that.
Good morning, Your Honor.
Good morning. Please place your appearance on the record.
Jennifer Bummer, Putnam County Attorney, 48 Glenade Avenue, Carmel, New York, 10512.
And counsel, have you had an opportunity to speak to the county legislative group?
I did, yes, along with legislative council. We met with the legislature last evening informally, and I do have the informal authority to move forward with the settlement today, pending the presentation to them on a formal legislative resolution.
Very well, thank you. Okay, is there anything else we need to discuss before we allocate the parties?
No, Your Honor.
No, Your Honor.
All right, Mr. Levy, would you please stand up and raise your right hand? Sir, you solemnly swear or affirm that the statements you're about to give to the court today will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Thank you, sir. If you're more comfortable, you may sit or you may choose to stand at your leisure, whatever you prefer. All right, sir, how old are you?
I am 48 years old.
And do you speak and understand English?
I do.
Is English, in fact, your primary language?
It is.
Do you understand, sir, that we've been engaged in the trial in this matter, and we are prepared to proceed to the trial after the opening statements that we had yesterday, and obviously the jury's picked and prepared to hear this matter. Do you understand that by entering into this agreement today, this trial will stop, it will end, and the matter will be adjusted and settled pursuant to the terms and conditions of the stipulation that your attorneys put on the record?
Yes.
And sir, is that what you want to do today?
It is.
Has anyone forced you, threatened you, or coerced you in any manner to enter into this agreement?
No.
Are you doing so of your own free will?
Yes, I am.
You've been represented throughout this matter by counsel, is that correct?
It is.
And you yourself are an attorney, is that correct?
I am.
Are you satisfied with the legal representation you've received in this matter to date?
Yes, I am. Yes, I am.
And sir, have you had sufficient time to speak to your attorney about the terms and conditions of this settlement?
Yes.
And sir, are you under the influence of any medication, narcotic, alcohol, or drug that would prevent you from understanding what you're doing here today?
No.
And have you in fact understood these proceedings?
Yes, I am.
Do you have any questions about these proceedings or this settlement or any other matter, either for me or for your attorney?
No, I do.
You understand, sir, if you wanted more time to talk to your attorney, I'd be prepared to provide that to
I
you.
understand that.
Are you asking me for more time, or do you want it to be resolved today?
No, I'm asking that it be resolved today.
Thank you very much, Mr. Levy. I appreciate it.
Thank you.
Sheriff Smith, please raise your right hand. Sir, do you solemnly swear or affirm that the statements and testimony that you're about to give today will be the truth, the whole truth, and nothing but the truth?
I do, Your Honor.
Thank you, sir. And sir, how old are you? Please put your arm.
I'm 69 years old, sir.
And do you speak and understand English, sir?
Yes, Your Honor.
Is English, in fact, your primary language?
Yes, Your Honor.
And sir, again, you understand that you've been involved and engaged in this litigation. We are at trial now. We have a jury in the back. We've begun the trial. We're prepared to continue it today. But that in accordance with this stipulation, this trial will end. The right to defend yourself and cross-examine witnesses and testify yourself and all of the other protections and rights normally associated with the trial, all of those would be waived by you in lieu of the settlement that's been proposed to me. Do you understand that's what
Yes,
the
Your Honor.
effect of this? Okay. And is that what you want to do today, sir?
Yes, Your Honor.
Has anyone forced you, threatened you, or forced you in any manner to enter into this agreement?
No, Your Honor.
Are you doing so of your own free will?
Yes, Your Honor.
Now, during the course of this litigation and this trial, you've been represented by counsel, is that correct, sir?
Yes, Your Honor.
And are you satisfied with the legal representation you've received from your attorneys?
Yes, Your Honor.
And sir, are you under the influence of any medication, narcotic, alcohol, or drug that would prevent you from understanding what you're doing here today?
No, Your Honor.
And do you believe that you in fact understand what's been preceding these proceedings and what the terms and conditions of the settlement are?
Yes, Your Honor.
Are you asking the court to approve it?
Yes, Your Honor.
Have you had enough time to talk to your attorneys about this?
Yes, Your Honor.
Do you understand, sir, that if you needed more time to think about it or discuss it with your attorneys, I would provide that?
Yes, Your
Are
Honor.
you asking me for more time, or do you want it to be resolved today?
No, Your Honor. I want it to be resolved today.
Thank you very much, sir. You may be seated. Okay, the court finds that the settlement agreement is knowingly, intelligently, and voluntarily entered into, and it will be, it's approved and so ordered. The stipulation of discontinuance with prejudice will be filed within the court within 3 days. If, Mr. Sussman, you need additional time, you let me know. I'm not married in 3 days, but I'd like to try to get it resolved on our inventory as soon as possible. In addition, I'd like to thank both parties. It's been a pleasure to meet you both. I've never had the honor before, but it was very nice to meet you. And I'd also like to thank you for your practical approach in resolving this matter. These things are never easy. They're always difficult. And while litigation provides an ultimate way of resolving every type of dispute, sometimes coming to an agreement, acknowledging what we've done and stand by it, own it if you will, and make a compromise is always a better way forward than to be arbitrarily determined by some other body. So I applaud both you gentlemen for seeing the benefits in that and getting it done. It's, in my view, it was befitting of the high office that each of you held, and I think have been very good at that in each of your respective positions. I also like to thank the attorneys. It's been a pleasure to work with you both. That is not always the case, but it certainly is when I am able to face the counsel such as you. You've been very prepared, very practical. We work very well together, and that's always something that the court can admire in our profession. Thank you very much for that. Okay, I will be addressing and discharging the jurors shortly. Is there anything that either side needs me to do or wants me to do before I do that?
No, Your Honor.
No, Your Honor.
All right, very well. At this time, we'll turn the cameras off, and we will, as soon as that's done, we'll bring the jury in.